So I have this morning set for the TRO hearing in the matter of Suzanne Wyman versus Timothy Wyman. So let me get a lay of the land just in terms of who I have here and what whose interests are represented here. I recognize Mr. Sobel. Is it Sobel or Sobel?
Either one.
Okay.
That's
Well,
both.
tell me what you prefer, and I'll say that. I just wanted
Uh,
to make sure I got it correctly.
yeah, no, absolutely. So it's good.
Um, okay, and I recognize your name from the pleadings,
Correct.
from some of the pleadings that I have seen. And who do I have? And you're representing Mr. Sabel?
Suzanne Wyman,
Okay.
who's the
And
petitioner.
okay, and who is representing Timothy Wyman or the trust?
Good morning, Your Honor. Nicole Wade with Wade, Greenberg, and Wilson. I am representing Mr. Wyman individually and in his role as trustee,
Okay.
and he is on the line as well, as you can
I
see.
yes, I see both of them. Thank you. Um, And I know my review of the file indicates that the complaint has been served, the petition has been served. Time for an answer has not run yet.
Correct.
And I believe that your presence here, Ms. Wade, has been accomplished likely because of my court's policy that is, look, we can go forward with a unilateral ex parte hearing, but the preference of Fulton County is if you can get notice to the other side and someone can appear on their behalf, let's have a more substantive conversation. And so I appreciate your presence, Ms. Wade, Mr. Sobel. I appreciate your reaching out to ensure that the relevant parties had notice. So one thing I do want to note for everyone's benefit is there is not a court reporter here. And that's because and I think our notices say that, actually, I know our notices say that we do not provide a court reporter. I, in fact, don't have an assigned court reporter currently. And so for future reference, if you do wish to have this taken down and a formal transcript made, you'll need to secure your own court reporter. To that end, I'll also note that you might have gotten a notification just a moment ago that this matter is being live streamed. Um, so in order to satisfy my obligation to have an open courtroom, a constitutionally open courtroom, we are live streaming it to YouTube. The reason I mention that is one, I'm sure we're all very boring and no one is actually watching this, so I wouldn't worry about that too much. But I do mention it because as an artifact of the way it is saved to Google, there may be a recording of this matter that is viewable on Google, like YouTube, etc. I mention that simply to tell you that is not an official record of this proceeding, and you can't use it to create a transcript of this proceeding. It's just an artifact that often gets deleted in due course. So I just mentioned that for y'all's benefit. Beyond that, we are here on a petition for a temporary restraining order. Mr. Sobel, I'm going to ask you what I typically do with um, with proceedings of this type is I'll say this. I have taken some time to read the proceedings. I am aware that I believe Mr. Wyman and Ms. Wyman are siblings, that their father created a living trust during his lifetime that he and or Mr. Wyman at various points either were or had the right to be the trustee of that trust. And it was part of an estate plan that sadly has now come to fruition because, as I understand it, their father passed away, I think, in July of last year, if I remember reading the pleadings correctly. And so what has arisen now it seems like what I've seen in the pleadings and in the motions filing is some effort to liquidate some of the property that is owned or held by the trust for the benefit of the trustees as part of liquidating an estate. And that there has come to be a significant disagreement between Ms. Wyman and Mr. Wyman, both of whom are beneficiaries of the trust, but Mr. Wyman is the trustee of the trust, about whether or not Mr. Wyman, as the trustee, is acting in the best interests of the beneficiary and whether or not he has breached any fiduciary obligation or breached the trust itself. So I say all that to say that's the limited universe of information that I think I have based on what's in your file and what I have read. So I'm sure there's more information that you want to provide me, but I always start with this is what I think I know about your case. So if any of that's wrong or incomplete in an important way, please educate me. And number two, start by telling me the relief that you want, because at this stage for an injunction, right, so much of what the court is being asked to do is to determine if relief is necessary and if that relief in the balancing test, right, makes sense in the larger structure. And so, for example, if you're going to tell me that you want, some crazy relief, then that might be a different assessment than for you to say, I want this this aspect of relief, which I think is measured relative to the potential harm. And so that's the analysis that I'm attempting to engage in. And so if you can start by telling me the specific nature of the relief that you want, starting with, I guess, at least an accounting, which is the number one thing that you've asked for in the petition.
Yeah.
And from there, Mr. Sobel, I will hand it over to you, sir.
Not a problem. Well, thank you, Your Honor. I appreciate you taking the time to set this for a hearing this morning. So essentially, the relief that's requested is, in our opinion, very reasonable. The petitioner is respectfully requesting that the respondent be restrained from at least attempting to consummate the transaction or the lake property transaction that's currently in place. As of, I believe it was August the 10th, we learned that the property is under contract with a pending closing, I believe, September the 14th. But basically what we're asking for is to allow the petitioner sufficient time to review and retrieve tangible personal property from the premises. We've also been asking since at least February, has been asking for a full accounting and complete inventory of the tangible personal property and other assets of the trust. To date, we have still not received a viable list and accounting, let alone an inventory of everything that's included in the trust. Now, obviously, that
Forgive me for interrupting, Mr. Sobel, but as I understand the trust documents that were provided to me, and keep in mind, trust not something I do a whole lot with, right? So, but as I think I understand the trust document, essentially all of their father's property, right, became a part of the trust either during his lifetime through the amendment or subsequent to his death as a part of the estate, correct? So it's
correct. That's pretty much everything.
okay.
However, over the course of several months and since their dad has passed, there's been evidence of the trustee going into the, certain property such as a safe that's at the premises, removing property from the safe, but then inadvertently on the inventory that was supplied, the contents of the safe was not really fully described and included. We've also got evidence that the respondent or the trustee has been requesting or allowing potentially family members, friends to go in and take certain properties. The reality is both the trustee and the petitioner, both the beneficiaries of the trust remain in Georgia. Everything that we're talking about is up in Michigan, and so it is a bit of a travel for everyone to go up there to see everything, to put their hands on it. But we've been asking very, reasonably for an accounting and inventory for months and months and months. We still haven't received anything that's satisfactory in our opinion. Everything that we do get seems to provide us with more questions, where we're actually seeking more clarification as to why things weren't included. We're also seeing evidence that the trustee has been commingling funds from an account. So there's a lot of evidence of that. Now that's more tied to the actual petition, not necessarily the motion for the emergency hearing. But that's all kind of tied in together in this.
And so in the immediate, when you say you want the court to restrain the lake property sale, are you talking about delaying it? I mean, is there a complete contract for purchase? You just want to delay the closing. You're not trying to break up the sale. Is that correct?
Not necessarily. So as of, I would say, June the 29th, I believe, we were so we were in communication with petitioner's counsel. It was not with Miss Wade. There was another counsel in Michigan that we were in communication with. Okay. And so the way that the structure was going down was that Suzanne and Timothy both had counsels in Michigan that were corresponding with each other. I was brought on to provide some assistance in Georgia because everyone was in Georgia at the time. And so during the communications between councils in Michigan, it was discovered that, essentially Suzanne had requested time to go into the home to retrieve personal items. There was even an agreement for my client, the petitioner, to purchase the interests in firearms that were at the property. From our understanding, Timothy, the respondent, had agreed to that. However, when Suzanne did go to the property, she was under the impression that only she could retrieve her own personal items and not tangible personal items from the trust. And so we requested a round robin effect to go in and retrieve certain items from the property in Michigan, beginning in June 29th of this year. We never got a response regarding that. We sent out a formal letter on July 13th, bring that issue right back up, asking for my client to go in and retrieve certain personal items through a round robin approach.
Forgive me, when you say round robin approach, tell me what you mean by that, because that's not a term I'm familiar with.
So essentially, it allows the petitioner and the respondent to individually go and flag certain items that they want from the property, from the trust. As long as everyone's okay with it, they can take possession of those personal items. So it's just going backwards and forwards. They've termed it as a round robin approach up in Michigan. And so it's similar to that in Georgia, where everyone is in agreement to certain assets being taken from the property, and this was in accordance, by the way, in the terms of the trust. So I don't know if you had an opportunity to take a look at the trust itself, but Article 2.2A of the trust, which is the amendment, expressly states that I give all the remaining tangible personal property not otherwise disposed of, such as household furnishings, appliances, and so on and so forth, to my children who survive me in shares of substantially equal value. And so my client was in attempting to obtain the personal items that she wants. Obviously, she was allowing, she has no discrepancy that Timothy could do the same. But that was never, came to fruition. After the July 13th correspondence that we had, communication ceased to exist. And at that time, we decided, at this point in time, it's best to go ahead and file something with the court, because we also discovered and learned that Timothy had gone through the safe, removed certain assets from the safe. We had questioned them about it. We gave them a 5-day notice to provide us with a response on July 13th, and it wasn't until the 29th that we decided we hadn't heard anything back. That's when we filed our petition. Shortly thereafter, after Timothy got served, which I believe was August the 10th, we discovered that not only was he not communicating, but he was actually listing the property, the lakefront property, for sale, and was potentially under contract. We learned that through third-party online searches. We also tried to reach out to the realtor through a friend realtor who confirmed that the property was under contract. Even after filing the lawsuit, having the respondent served, the petitioner's counsel, Michigan counsel, even followed up with the Michigan counsel for the respondent, asking to confirm whether or not the property was under contract and what the status was. We got no response. Basically, the response was that Georgia Counsel was going to go ahead and handle it from here on out, but didn't provide us with contact information for Georgia Counsel. And if I'm not mistaken, Ms. Wade was just recently retained as well. So this is a recent up-and-coming case for her. And I'm not quite sure in terms of when we filed the emergency petition and when Ms. Wade was retained. But as soon as we filed the emergency petition, we provided notice to Michigan Counsel, and at that time, that's when we were afforded the information for Georgia Counsel.
Okay. Well, the nice thing about having Ms. Wade involved is that now
Yeah.
there's, other than having to go through Michigan Counsel, now there's
Yeah.
at least a lawyer in Georgia that you can communicate with.
And Ms. Wade and I haven't even communicated because this is so fresh and new. And so what we're trying to do is the relief that we're actually requesting is just enough time for the petitioner to go through and remove tangible personal property in accordance with the terms of the trust, to go through, make sure that there's a full and complete accounting and inventory of all the tangible personal property to make sure that nothing was disposed of, sold or anything like that. And then allow sufficient time for the petitioner to evaluate whether or not the lake property transaction, including all the furniture, is a good deal. That's basically where the relief is coming from. It's more temporary. We understand that it's the deal that's on the table right now is 1.41 million for the property, but includes all the personal property as well. And the respondent hasn't provided my client with an opportunity to collect the tangible personal property that's afforded to her.
Okay. Thank you, Mr. Sibel. And because it's your motion, what I'm going to do is I'm going to hear from Ms. Wade, and then it's your motion, so you will have an opportunity to respond.
Not a problem, Your Honor.
Okay, Ms. Wade, your response?
Thank you, Your Honor. And as Mr. Sibel noted, I was just engaged last week and came in and thought I would be filing an answer in 30 days. And instead, I got a TRO on my lap. So I have gotten up to speed as much as I can. So please forgive me if my if I don't recall dates and specific things as specifically as Mr. Sobel might, because I have tried to get my arms around this. First, I want to make sure that Your Honor received the affidavit and brief that we filed yesterday. And I would have liked to have filed that earlier, but again, I did the best I could.
I have not received it. It has not yet been docketed in our Odyssey filing system. And I have not received it via email forward from my staff. But if you want to, if you want to email it to me right now, I will probably get it right now.
And I
and then I'll have
apologize
access to it.
for that, Your Honor. I thought it was emailed to Mr. Freehoff, but
It may have been. I think
it
he
may
was
not
out.
have been.
Yeah, he was out yesterday, and so it may be that I can't even imagine how many emails he gets in a day because
I
most of them are,
can't.
so I don't have to get them. So it's entirely possible that it was forwarded to him and he's just not had a chance to go through the however many hundreds of emails he gets in a day. So
Well, and Your Honor, I will say this, I was provided with and if it's okay, may I take just a second and find this and forward it to the court?
absolutely, yes. Mhm.
Okay, sorry, I just, let's see. Here's the brief. And I'm sorry, what is the email?
To save everyone time, I just forwarded it to the
Oh,
judge.
thank you so much. Good, thank you.
And it was 211 emails, so I apologize.
Yeah. Like I said, I knew it was a lot, so thank you.
Well, and the affidavit that we filed from Mr. Wyman, I think there were like 500 pages attached. And so my paralegal, I think, sent the PDF and then a link to the documents. And I would very respectfully ask the court to make sure that You review all of that before granting a TRO, because I honestly, Your Honor, I don't understand why we're here. I've been doing this kind of litigation for 30 years. When I dug into this weekend, I was expecting to see all kinds of holes and wondering what I was going to come across. The communication has been great, Your Honor. My client has communicated, and I'll just refer to them as Tim and Suzanne, if that's okay with everyone, given
Yeah,
the
just to
last
avoid,
names.
and normally I do
Right.
not refer to people by their first names, but yeah, for avoiding confusion, yes.
Yeah, otherwise it's going to be, yes. They were communicating, and this is throughout the brief that we filed and throughout the affidavit. But they were communicating pretty much from the beginning. In February, my client had the liquid trust assets distributed in their entirety. It's about 1.5 million. That was distributed out to the two of them entirely. He retained $1,000, I think, from that, which actually just came in after the fact, and has been using that and the proceeds from the other assets that he has sold to pay bills and things like that. So the cash, it wasn't cash, it was actually securities, but I'm calling it liquid because it was able to be transferred. The cash was transferred out immediately. That left the assets that Suzanne knew about. They had been emailing about them. And you'll see we put in emails, particularly in December and January. They really started talking about, what are we going to do with this? What are we going to do with the mobile home? What should we price it for? You'll see text messages between the two of them, messages from Suzanne saying, yes, I've been looking at the comps and it's priced too high. We really need to get rid of it. And Tim saying, okay, I'll have the realtor drop the price. We have emails with Tim saying, do you want to buy my share of the lake house? Should we just sell it? You'll see all kinds of communications like that. They were getting along, it looked to me like, very well. I don't know what it was that happened in February, but for some reason, immediately after the funds, the 1.5 million was distributed, an attorney popped up on her side and said, okay, we want an inventory. We want to know what's been spent. We want all of this. So my client's Michigan counsel immediately sent a letter March 5th, and it's attached to Mr. Wyman's affidavit at exhibit, I think 5. No, I'm sorry, 7, sorry. And it has, I don't know, 12 or 13 exhibits. He attached everything. He attached statements, all of the statements that he had for the trust account, which in fact, and I'll back up, those had been sent to Suzanne at the time she got the distribution of the trust assets. My client had the banker also send her copies of all of the trust statements. My client had previously emailed her and told her what had come out. I think there had been like 6 or 7 payments out of that account for a few $1,000s. He had previously emailed that to her. The Michigan lawyer sent Suzanne's Michigan lawyer copies of the Roth IRA statements, even though that wasn't a trust asset, that had also been distributed. That was, I think, $900,000. He sent copies of the SEP IRA statements, again, even though that wasn't a trust asset, that had been distributed. I think that was $500,000. And I may be getting these figures wrong, but something like that. He identified an offer they had on the mobile home. He identified the real property. There were 2 pieces of real property, the farm property and the lake property. Now, the farm property is actually, the address is actually Wood Lake Road, which has been very confusing to me, but that's the farm property. And the lake property is on Harbor Drive. He sent copies, this is perhaps most relevant to this TRO, but Tim's Michigan lawyer sent Suzanne's Michigan lawyer copies of 2 appraisals that they had for the lake house. Tim had immediately gotten appraisals on both properties. And the two appraisals were, one was for $1 million. One was for $730,000. This is the property that Tim has now negotiated a contract to sell for $1.41 million. Suzanne previously approved a contract for the sale of this property. So this notion that they didn't know it was listed, didn't know it was for sale, didn't know what was being sold with it, it's just not true. There was a contract previously. It was sent to them. And again, when I say them, I don't necessarily mean Mr. Sobel. I don't remember seeing him involved in this. I think this was all between Michigan Counsel. So I don't know to what extent he was involved. So I'm not trying to throw stones. I have no idea. So when I say they, I mean Michigan Counsel. These communications were all between Michigan Counsel. But I know that Tim had also initially sent Suzanne copies of these two appraisals. And in fact, he sent her, he first sent them to her February, I believe. No, I'm sorry, I think it was December. And said, here are the two appraisals. Do you want to buy my share? Do you want to buy me out? Well, she never took him up on that. So it was listed. They knew it was listed. They sent an email at one point after they found out and said, take it down, take it down. We don't want it to be listed. My client immediately took it down. The next day, took the listing down and said, what's going on? What's wrong? That's how responsive he has been. Well, even after he took it down, they got an offer. And the offer was at 1.6 million. And Suzanne approved that and said, that's great, let's do it. That offer fell through. The buyers, something happened with the buyers. They didn't sell their other property or something. And so there was a discussion, again, this was via emails, which are attached to Tim's affidavit. And the broker said, okay, I think it was $15,000 in escrow money. Here's what we can do. We can either try to hold their feet to the fire, or we can let them out and we'll split the escrow money with them. Here's the deal. If the appraisal comes in at 1.6, the escrow money will be ours. If the appraisal comes in below 1.6, the appraisal money will be theirs. And so the two Michigan Counsel had some back and forth on this, and they both agreed that the appraisal was unlikely to come back at 1.6 because they had two appraisals in hand, the highest of which was 1 million. And so they let the buyer out and said, okay, fine. And Tim's Michigan lawyer said, we think we should let him out, get it relisted again as soon as possible. And her lawyer said, great, perfect. So that's exactly what they did. And then they relisted it immediately for the 1.6 again in June. And this is a lake property in Michigan. I don't know if your honors ever spent much time in Michigan, but
I've actually been to a lake property in Michigan. I'm sure there are a million because there's lots of lakes in Michigan. But that's
are a
about
lot.
the extent of my experience with lake property in Michigan.
Well, the season there is somewhat truncated because it gets very cold very quickly. I went to law school in Michigan, and I remember being shocked at it being so cold in October that I couldn't wear a costume because it was too freezing. The season is short there, and so the goal is to sell your property before Labor Day. That is the absolute goal, because after that, people just wait until the spring because it's lake and it's Michigan and it's freezing. So I think it's about 2 or 3 weeks after they relisted the property in June, they had no showings, none. So the realtor, and this realtor, we put in a link to his bio, and he focuses on selling only Southwest Michigan lake property. To your honor's point, there are so many lakes, right? He can focus on Southwest lake property. And he said, look, we need to drop the price. We're not getting any traffic in here. We need to sell this before Labor Day. And Tim's lawyer reached out to Suzanne's lawyer and pointed this out. And then that's when this was July. They waited several days. This was early July and said, oh no, we think she needs to, look at when she needs some time, she needs to do appraisals, whatever. So Tim had to make a decision here, and he made it, and he decided to drop the price. And frankly, this was the first time in this entire trust process that he did something without not just giving her notice, but getting her approval, which he did not have to do. He has authority under the trust instrument. He has authority, and let me make sure I get this right, to deal with any property held in the principal as freely as I might in the handling of my own affairs. That is the language in the trust instrument. He has, when it comes to his authority to sell property, he has authority to sell property for such consideration, if any, as the trustee shall deem proper. I've actually never seen such broad discretion, such consideration, if any. It's pretty broad. So
well, let me ask you a question, Ms. Wade, because
yes.
I think that while the history and that provides context and helps me understand, the ongoing dealings that got us here, as I understand the petitioner's request today, it's not to undo the sale. It is merely to delay the sale, or as I understand, at least at one point, them saying no one's ever disclosed to us when the closing is, so we don't have any way to make arrangements. And so if no one's attempting to obstruct this sale, then I guess when is this closing scheduled, and what arrangements can be made, or is the trustee willing to make, to allow the removal of the private property that apparently there was some contemplation of being marked and taken, and therefore necessarily would have been excluded from any contract for sale and acceptance and offer of the property, including its contents?
Sure. Sorry. And I think just the background is helpful just to see where we are and how we got here. But the sale, the contract was executed, I believe it was August 8th. I mean, the contract was just executed days before my client was served with this.
Well, sure, but I mean, 30 days to close on a real estate property is not unreasonable. Sometimes it can be shorter depending on if it's a cash offer. And if the offer was accepted on the 8th, it's the 25th. I mean, we're less than 2 weeks away from 30 days from the date of that offer.
The offer was accepted, I believe it's the 9th. We attached it to Tim's affidavit. Everyone has it now. I think that, and I can't speak for Michigan Counsel, I've spoken to him one time, but he is not a litigator. As soon as he found out that litigation had been filed in Georgia, he froze and he said, okay, I don't know what's going on. I now have nothing to do with this. So, what would my preference have been? For him to have simply sent the contract? Of course, but it was, that just didn't happen, and it didn't happen. But it has been provided to them now. The closing is scheduled for September 14th. This is an objectively good deal. There is no appraisal contingency.
Okay, well, but hang on. So I don't know that I don't question that it's a good deal. I mean, I don't know that issue is in front of me, because as I understand Mr. Sobel's presentation, Ms. Wyman, Suzanne, is not disputing or attempting to undo or challenge this sale. What I understood Mr. Sobel's request to be is, when is the closing and when can we make arrangements for me to get personal property out of the house? Now, the only thing I've heard so far that would give me concerns about that is whether there's some dispute about what the purchasers believe they have purchased and what Ms. Wyman believes she can remove from the house. But I don't understand her at this point. Maybe that was a position they took earlier on in this process. But right now in front of me, I do not understand the argument to be, you cannot sell this house. I understand the argument to be, if the sale is going to go through, what arrangements are being made for me to be able to get personal property out of the house? And how do I know what personal property is mine that I can take and what personal property goes with the contract, because apparently it included contents, some or all contents.
And I can address that, Your Honor. If I misunderstood, again, my apologies, but it was my understanding that the TRO is asking that Mr. Wyman be prevented from consummating the sale.
But that's why,
So-
Ms. Wade, I always start at the beginning of the hearing with, tell me what relief you want, because all attorneys in the history of ever ask for the sun, the moon, and stars of every bit of relief they could possibly want or think they might be entitled to. And then when you get down to brass tacks and you prepare for a hearing, you think, okay, this is what I really need for purposes of this hearing. And so that's why I started with the relief Mr. Sabel was requesting. And as I understand it, the request here today is not to restrain Mr. Wyman from from closing on the lake house. I understand the issue to be, when is the closing and how will we deal with the property? And to the extent that Mr. Sobel did say something about restraining the sale, I understood him to be talking about delaying the closing until the personal property issue was adjusted. And Mr. Sobel is nodding, so hopefully that means he's agreeing that that's the understanding that I have and that it is currently correct.
And I guess from my perspective, there is a contract. The closing is scheduled for September 14th. Again, we are talking about a Michigan lake house. So I'm not sure that delaying the sale is possible. But let me address.
And one way to not delay it is to figure out what is the timeline and what are the disagreements and agreements about Suzanne Wyman obtaining what she believes to be her personal property from that house.
And let me address that, since Your Honor has asked, and I have not addressed that specifically. And again, my apologies if I'm a little scattered. I'm trying to focus.
I'm impressed with how much knowledge y'all all have about something that is quite complicated and is happening very quickly. So don't worry. I'm just trying to key us in on what I think are the issues, and you're good.
I very much appreciate that, Your Honor. There has been no round robin or anything like that with respect to the property, because Tim told Suzanne, take whatever property you want. He told her many months ago, and I don't know what date. I don't have the date of that in front of me. I can find it, but there is an email or a text from, and I forget if it's from Tim or his counsel, and they said, have Suzanne, this is when the first contract was pending on the lake house. And the message was, have Suzanne go take whatever she wants from the lake house before whatever the date was in May or June. Have her go take everything. And the answer was, okay, we will. And apparently she went to the lake house and took certain property. Tim said, okay, he doesn't know what it was. He doesn't care. He was letting her take whatever she wanted. Now, there has been some communication, and I've only seen this very recently, like maybe in the July stuff, where they said, oh no, she only took her personal property and not whatever personal property she wanted of their father's. I don't know anything about that. All I know is that she was entitled to take whatever she wanted. If there's something else she wants, I don't know that the buyers think it's part of it. I don't know the answer to that, but I haven't heard anything about what it is or anything else. She gave Tim approval, and this is why the first contract is so relevant. She gave Tim approval to sign that first contract that also included all of the furnishings, all the personal property, everything. So Tim had every reason to believe that anything personal that she thought should be taken out, that she had already taken it. Why else would she have given him specific authority? And Michigan Counsel, to his credit, said, to be clear, does Tim have authority to sign this contract? And he responded,
I did see that text. Yes.
Thank you. And that sale also included all of the furnishings, all the personal property, this pole barn, which I had to learn what that was, the boats, everything. So when Tim signed this new contract for what he believes is objectively a good price and included all the furnishings, he didn't think it was necessary to give her notice. Again, she had already approved it. So Tim has no objection to her having whatever personal property it is. I don't know what it is she wants beyond what she took before. Tim has worked with her at every opportunity and is happy to work with her again to the extent he can and to the extent it doesn't blow up this contract, which he thinks they absolutely need to get closed. So if somebody wants to tell us what it is exactly she thinks she should get, I'm happy to discuss it with him. Suzanne has been to the lake house several times, or at least a couple of times since their father's death, is my understanding. She's shaking her head no, but that's my understanding. Mr. Wyman was up there at his father's funeral and has not been back. So she knows what she took before. She knows what's there. Tell us what you want, and we'll figure out if it's something that has to go with the property. And if not, she can take it. It's really that simple. That's why I said I don't understand why we're here, really.
Okay. Okay. If you will give me about 3 minutes, I'm going to get a fresh cup of coffee, and then I'm going to come back and hear from Mr. Savell in terms of his rebuttal. And I'll be right back with you. It's 9:45. Like I said, just a few minutes. Thank you.
No problem.
Perfect. Thank you.
Okay. Ms. Wade and Mr. Sabell, I did take a quick break. Thank you very much. I have fresh coffee, so I'm good. I did have one question, Mr. Sabell, in terms of your rebuttal.
Yeah.
So what I've been saying about your client's position relative to the closing and the personal property, if you could confirm that you believe that is accurate. And then the separate issue is you did say that the additional relief that you were seeking was related to a thorough and complete accounting of the trust property. And I guess one question I have is, I understand that to be a much broader request than just the lake house.
Correct.
And would it exclude the personal property that is at the lake house that is being sold with the lake house as a part of the contract?
I think if we would narrow it to the actual lake house that's subject to the closing, I don't find my client having an issue with that. The reason why, we've been asking for an accounting and inventory since February. Everything that we've been getting is providing us with more and more evidence of self-dealing, commingling of funds, and it's bringing up more and more questions and concerns as to his breach of fiduciary duties. And so that's kind of why it ties into this aspect of it, because there has been a very recent history relating to this farm property that Ms. Wade was alluding to, and also the communications, because the communications between our respective clients have been relatively forthcoming prior. However, communications for some reason ceased to exist following the July 13th letter that we had sent out. And that's kind of when everything kind of hit a fan, if you will. Since filing the petition, we've learned that the farm property that we're talking about, or that we've alluded to, yes, we were under the impression that it was listed for sale, but what Ms. Wade hasn't expressed, I don't think clearly enough, is that farm property did not close on the deal that we were aware of. The farm property that was being sold just included the farm. We were not informed that the new listing and the property being under contract also included personal property that was primarily dealing with farm equipment.
Let me ask you a question then, Mr.
Yeah.
Sabell, and I don't want to get too far into
Yeah.
the trust document because I don't know that is legally the issue that's in front of me right now.
Yeah.
But I know that when I was reviewing some of the materials, the exhibits that you had provided, and some of the back and forth with the attorneys, where there's permission being requested and approval being requested back and forth, I remember thinking, what obligation does the trust have to ask permission, right? The trustee generally of a trust, as long as there's no argument that there's a breach of a fiduciary obligation or that they're not acting in the best interest of the trust and or the trust's beneficiaries, they generally are allowed to do what they will. That's the authority that the trustee has. And then Ms. Wade has pointed out that she believes that not only does the trustee in this situation have that authority, but that it is just about as broad and unfettered a level of discretion. And again, I don't need to make a legal decision about that, but in light of language like that and the fact that structurally The trustee doesn't generally have an obligation to get approval or authority, right? So long as it's marshaling the assets appropriately and can account for them, which Ms. Wade has represented that she believes can, right? That there are explanations for all these things that Ms. Wyman is taking issue with. How do I reconcile that with Ms. Wyman's argument that she, for example, needed that the trustee wasn't authorized on this farm property to make an adjustment? Because I didn't read in detail, but I did see some of the materials that were presented indicated that initially there was an offer that was accepted, that it didn't go through, and then a later offer that was slightly lower now includes the farm equipment. But, so far, I guess my question is, I'm not sure I understand why the trustee would not be authorized to engage in those types of transactions, and why would if nothing else, let's say that the farm property sale goes through and Ms. Wyman is successful in her larger petition in demonstrating that that was a breach of fiduciary duty or a breach of the trust because the property was worth a great deal more and the trustee didn't undertake in good faith to maximize the value. Isn't that a money damages remedy that Ms. Wyman would then have? And if there is a money damages remedy, is she entitled to the equitable relief that she seeks here?
Yeah, so Your Honor, we're not actually questioning the authority that's afforded to Mr. Wyman at all in terms of this. While he does have broad authority to engage in the activities of listing and selling the property, he doesn't have the authority to just go ahead and ignore certain provisions of the trust. Mainly Section 2.2a, which is allowing all the tangible personal property to be split between the children equally.
Okay, but let's focus on the lake house for a moment, right?
Okay.
I did read that provision.
Yeah.
And so I understand. I think that may be, and you can correct me if I'm wrong, that may be where this word personal property began to be used inexactly between and among the parties. Because I think that the way that provision is written, if Suzanne believes that because of that provision upon his death, half of all the personal property became hers, that when she said she was going to go and get her own personal property, perhaps she was referring to stuff that was hers before, but I think perhaps she was referring to what she believed was hers as a result of the transfer by her father and then his death. Setting that aside for a moment, here's where I'm confused. If we are focused on the lake house, Ms. Wade's argument is the trustee's official position has been go get what you want. And also, the contract that the trustee has entered into on behalf of the trust is for the sale of the entirety of the furnishings and personal property that is in the house. And so, if that's the case, then why would there need to be an accounting, right? If Ms. Wyman can go get whatever she wants, and if whatever she doesn't take is being sold with the property and everybody's all in agreement with that, why would there need to be an accounting of that individual property?
So the reason why we're asking for more of an inventory and an accounting is because we do have evidence that certain items from the premises, the lake property, has been removed, could be hidden. We want to make sure that nothing is included in the sale, and what is included that we know of, we can remove. And so, simply because our clients are in Georgia and don't have free access to quickly just drive up and go to Michigan, with the time frame of the sale going through, we wanted a full accounting to make sure that my client, the petitioner, has an opportunity to know what's in the house and to be able to remove things through that round robin approach. You are correct that previously there was discussions about my client going to the property. However, there was a misunderstanding in that communication where my client, Suzanne, was under the impression that she could only retrieve her personal possessions. So remember, this is a family home. She used to live there. She was getting stuff that she believed was hers, not part of the trust property. She never got anything that was trust property related. And when we discovered that after the fact, I would say mid-June, definitely in late June, is when this issue came up, where we discovered that, Suzanne didn't actually collect the tangible personal property of the trust. She only collected her personal possessions. That's when we provided an option for maybe a round robin approach to allow everyone to go in and retrieve anything that they wanted out of the home.
But
This is
but
way before the
here's where I get
contract.
confused.
Yeah.
There isn't an everyone, right? Granted, I understand there are probably
Right.
grandchildren and nieces and nephews and cousins and family friends that might have an interest here. But at the end of the day, there isn't an everyone. There is a Tim and a Suzanne, because they're both still living, which means that none of even their children have an interest in the trust, right? They are the only beneficiaries of this trust, as I understand the trust. And
And
so, as I understand what's been represented to me today, Mr. Wyman has said, go take what you want. Now, there might be an issue if Miss Wyman's intention is to back up a moving truck and take all of the personal property and furniture out of the house, since the buyers anticipate that they will be getting some or all of it. But I guess in I guess if Mr. Wyman says his position is go take what you want, then why can Ms. Wyman, without benefit of a TRO, right? Why can Ms. Wyman not just go to Michigan sometime between now and September the 14th and say, this is what I want? And Mr. Wyman will say, okay. I mean, because that's what he's represented to me. He was going to say, again, I know that's a little squishy, because if you were to say, okay, well, then I want everything in the house, that would be a problem to this purchase agreement for the sale of the property. But if there's a good faith middle ground here, I'm not sure why we can't accomplish that. And you wouldn't need injunctive relief because Mr. Wyman, through his counsel, has said you can do that.
yeah, you're on. And let me just clarify. When I said everyone, I misspoke in terms of meaning Timothy and Suzanne. So that's kind of what I meant by everyone. Okay. Yeah, but in terms of why my client may not be able to go to the house is because right now we're under contract. There's a contract, and stipulated in the contract expressly states that all the tangible personal property, furnishings, and including some boats that are at the property, are subject to the contract. And so what my client doesn't want to do is go in and remove personal items, and then all of a sudden we get a complaint brought up against us for causing a breach of contract. We
But
have not been aware of this contract up until yesterday.
But it feels, I mean, due respect, I understand your client's frustration, right? And I feel like that a more formal process when there is disagreement could probably have solved this issue beforehand. But where we are now, let me say this. There's no universe in which on a TRO, this court is going to say, Miss Wyman gets this lamp and Miss Wyman gets this sofa and Miss Wyman gets this boat, right? But as I understand, and I don't have the benefit of the purchase and sale agreement for the property, but I've seen a lot of them in my lifetime, and as I am imagining, what it is saying is for the sale of the property and associated personal property, which would include primarily the primary pieces of furniture, and it's going to include, as I understand it, specifically boats and watercraft that are associated with that property. So and my understanding further is that there has at various points been agreement to sell the property, agreement by Ms. Wyman, albeit, again, I'm not sure legally that her agreement is required, but an acknowledgement by Ms. Wyman that the sale was going to occur, including those pieces of personal property. And so I guess one thing I'm asking is, we have between now and September 14th for Ms. Wyman to actually go and say, these are the things I want. And all of that can be negotiated. right? All of that is something that Suzanne can say, I want X, Y, and Z, and Mr. Wyman can say, fine, take it. Or Mr. Wyman can say, well, you can have X and Y, but Z is a boat and it's part of the contract and you can't take it. And then maybe y'all could disagree about that. And then maybe Ms. Wyman could argue that she was deprived of the benefit of the boat. And then we get right back to, is that a matter of monetary relief, or is it a matter for equitable or injunctive relief? What I'm trying to get to is part of, I'm not sure I understand. I agree with you that 9 days is not a super long amount of time, but it is not unreasonable to imagine a universe in which the parties could go to that house because whatever personal property is going to need to be removed prior to the closing, because you've got to be able to deliver the keys in the condition anticipated by the 14th. So if in fact that can be accomplished, and if in fact there is some agreement / negotiation that can be made regarding what personal property Ms. Wyman wants out of the lake house, then I want that to happen. And I'm not sure why, if Ms. Wade has said, Mr. Wyman is like, take what you want. And there is a 9-day window that we have in front of us for us to accomplish that without restraining the sale. Then I guess my question is, 2 of the 3 matters of relief that we were here discussing, I'm not sure why we would need injunctive relief. Now, admittedly, if you were to go this week, we might all be back here on Monday of next week or Friday of next week having the same conversation if things break down. But it feels like there is a potential window to negate the need for injunctive action by the court on 2 of those issues. But that is also why I come back to this third issue, which is, if you're talking about an accounting of the larger trust property, then let's talk about why that hasn't been provided, what it is. But if we're talking about an accounting of the lake house property, I still question the necessity of such an accounting if 2 things are true. Number 1, the trustee has said, Ms. Wyman, go take whatever you would like. And 2, everything else is being sold with the house.
Yeah, so in terms of, so there's been a history as well in this where, um, absolutely, if everything goes smoothly, my client has the opportunity to go up north and retrieve all the items. However, there is a third party in this, which is the potential buyer. I don't know if the potential buyer's got, an interest in the property that's now listed in the contract. This is not a 2-way party now. This is a 3-way party of negotiation.
But isn't that the trustee's problem?
It
Right? I mean,
is.
that's
It is.
that's the trust's problem if they're not able to deliver the thing that
Absolutely.
they're supposed to deliver.
Right. However, in the history of this situation that's unfolded, as for an example with the farm property, you know, originally we were under the impression that only the farm property itself was being listed and sold. We found out after the fact that actual farm equipment, the personal property that was listed on the farm, was actually included in the sale for the same price. Some of that farm equipment exceeds $15,000. Like a tractor was in excess of valued at in excess of $15,000. There's boats that are at this property that are potentially in excess of $20,000 that are going to be thrown into this deal.
Well, they actually already have, right? There is a contract to purchase them. The
Right,
boats are included, subject to closing.
correct. But that also includes the furnishings, furniture, and everything else that's included inside the house. There's also a safe that's at the pole barn that I believe would be also included, which, from my understanding, Timothy is claiming that he hasn't even accessed that yet. He's potentially, we've seen that he's accessed it, in July and removed everything in July. But
I think I have not seen I have not seen the contract for the sale of this property, but I find it difficult to imagine a universe in which someone would sell a piece of property with a safe on it, especially if no one had opened the safe to determine what was on it.
that
Um,
That's what the
or
respondent's
what was
claim
inaccurate.
is. Yeah, so, the respondent is claiming that he's never been to the property since his dad had passed. We don't know what's at the property.
But again, what I'm struggling with is Mr. Wyman has said, go to the property, take whatever you want. It still belongs to us between now and September 14th. Why does that not address? Why does that not grant Ms. Wyman the relief that she wants?
Because first and foremost, prior to this hearing, we were advised that our client, Suzanne, and her husband were not allowed at the property whatsoever without permission. And we weren't
Okay.
given authority to do so.
Okay.
Okay. As of now, the risk is what happens if our client needs more time than September 14th.
Well,
And
due respect to your client, but we're talking about 9 days, and I have heard you ask to restrain the sale to delay it, but I haven't heard any explanation for why in the next 9 days, Miss Wyman can't go to the property. And that would be the reason that the court would consider delaying the sale. I mean, I have a very busy schedule, but if I needed to, I could get on a plane right now and go to Michigan and go through my family's home and decide what I wanted. And I wouldn't love that. I wouldn't love feeling forced to do it on a quick basis and a quick turnaround, but I could do it if that's what I thought was necessary to ensure that I got the personal property from my family's home that I wanted.
right.
I'm sorry, may I interject for one moment?
Yes.
Because I have another thought on this. And I'm not even going to address all the things from before. I'm just going to focus on this property. But the property sale will involve the safe. This is one of these gun safes that's like, 7 feet tall and 4 feet and weighs however many, hundreds of pounds. Not what's in the safe, but the safe itself, but not what's in the safe. Ms. Wyman did, Mr. Tim had, it's hard for me to even call them by their first names. I keep getting confused. Had said
Me
that
too.
the guns, he thought the guns were worth about $2,000. She said she would buy them from him for $1,000, and he said, okay. And then they wrote back again and said, well, you didn't answer about the guns. And Michigan Counsel said, yes, we did. She can have them. She can pay him $1,000. When is she going to pay it and how? And he'll give her the guns. So that's just outstanding. But what I was going to suggest is there is, the two siblings have a cousin, Shelley, who lives there in Michigan, very near the house. Shelley apparently is someone that their father relied on to help him with a lot of his things since she was there. She was listed on a bank account, for example, that they had locally to help him pay bills and that sort of thing. She has access to the house. If there's something, again, and I agree with Your Honor, Suzanne has been there, or her husband has been there. They've been there. And there are pictures, many, many pictures. Well, this is the house they grew up in, I guess. So I guess they know what's there. But there are also pictures in both of the inventories that have been provided and that are again attached to Tim's affidavit. If they would simply say, here's what we want, then Tim can make sure with the buyers that that's not going to cause a problem. This contract says the same thing the first contract did, which was going to close in July. Says the same thing. Furnishings, furniture, and yes, it says the boats, the fishing boat, motor, trailer. Apparently only one of the boats is really worth much, an 88 Ski Nautique, and I think it's worth $10,000. Tim had offered to give that to Suzanne in exchange for $5,000. He would pay her $5,000 and she could have that. And she said, no, sell it. So it's part of the property. So they're selling it as a turnkey property. She had the opportunity to take $5,000 for that. But I'm wondering if perhaps somehow if she can identify, if she says she can't go to Michigan, why can't she just identify what she wants? If it's knickknacks, I mean, if she's not taking out, like you said, backing up a truck, taking out all the furniture, taking out appliances, taking the boats. If it's knickknacks, personal items, I would think, and someone can correct me if I'm wrong, I would think Shelley could just go retrieve them if she can't get to Michigan. Just trying to offer solutions.
Your Honor,
Mr. Sib-
I do want to preface or discuss the boat because in accordance with an agreement between all the family members, Suzanne, Timothy, and their father, the boat was actually valued at $20,000, and so the agreement was that Timothy was going to purchase the boat, or Suzanne was going to purchase the boat for $10,000. So the valuation of $10,000 is inaccurate in accordance with the terms of the agreement between the family members. But that's just one of the issues in
When was that agreement, though?
this was prior to their dad passing away. Um, it was agreed that the property or the boat was valued at $20,000.
Right. I mean, I only asked that question because boats aren't like houses. Boats depreciate. They're just
Right,
like cars.
right.
And so
So it's
if 10 years ago the boat was worth 20 grand, it's not worth 20 grand
yeah.
now, even if
So,
we all agreed it was back then.
so this was my understanding. This was an agreement or a discussion right before his death, which was last year,
Mhm.
uh, July of last year. But even to this day, if you were to research that boat, the fair market value on an 88, ski Nautique, could be valued at anywhere from 12 to 15, upwards of even more, depending on the quality and condition. From my understanding, this boat has got very low mileage on it, and is in very good condition.
But-
Um,
Well, but I mean, I don't, I have not gotten into the weeds of this, but I just heard Miss Wade say that the offer was made to Miss Wyman to buy the boat and she said, no, sell it with the property. I don't know if that's accurate or not, but I'm just saying that's what Miss Wade has just
so
represented.
Right. So the representation was inaccurate because Suzanne was not willing um, I believe it was the other way around where Timothy was going to buy the boat and only give Suzanne 5,000. And she's like, no, it's $10,000. And that's where the disagreement came into play.
Okay. So
Sorry,
here's
I'm trying. Sorry.
here's what I'm struggling with, Mr. Sabell. On a TRO, right? The purpose of a TRO is to give you relief that you cannot otherwise secure, right? To protect and restrain the status quo. But what I'm struggling with here is that the relief that I understand you to be at Ms. Wyman to be asking for, Mr. Wyman has said she can have. And to the extent there is a dispute about particular items of personal property, for example, the boat. For example, the contents of the safe, Mr. Wyman denies having any knowledge of the contents of the safe or having access to the safe to remove items from the safe, right? So if there is a dispute about particular items, then the court might need to address those issues. But right now I'm being asked to do it in a vacuum because right now Ms. Wyman hasn't said, I mean, now the boat and the safe are a bad example because there is some discussion about she's saying she wants it now. But one response is going to be, but that wasn't what we agreed to. And when I said I was going to sell the house with the boat, you said okay. So that's the situation we're in now. I know that I've heard multiple times in both the pleadings and today, an issue related to the safe's contents and whether or not anything has been removed. But the rest of the personal property in the house, I can't. So far, what I have is Mr. Wyman saying, take whatever you want. And I haven't, to my way of thinking anyway, unless and until Mr. Wyman says, no, you can't have that. I'm not sure why I would need to enter a restraining order that allows Ms. Wyman to get personal property from the property when there is no basis for me to grant that relief when that relief is already being offered. I also, as I said a moment ago, I still don't understand why we would need to restrain the sale of the property from September the 14th. Like I said, I know it's a tight window, but it is a window nonetheless, where, either through photographs or through physically going there, a review of the property and an I want this, this, and this could be accomplished. And frankly, if that were to occur in the next short term, the court can even accommodate a further injunctive hearing regarding any disputes that arise from that personal property prior to the September 14th closing. I mean, we can we can try to work through this without delaying the sale, because the setting aside whether the arguments Ms. Wade has made about her entitlement to approve and or to take personal property from the property, setting all that aside, it sounds as if um some of the relief that has been requested is willing to be provided by the trustee. And then that again leaves us with the accounting of the trust property. And I think I still am not quite sure, Mr. Sobel, are you looking for a full accounting of all trust property? Is that what we're talking about today? Because I've heard about other pieces of property, or are we still talking about the lake house?
I think we're just talking about the lake house as it's relating to the sale, because we want to make sure that Suzanne has an opportunity to go and get everything that she would want out of the trust, out of the
Okay,
property.
and so if she were to go to the house, or have some opportunity to review the house and its contents, it seems to me, and tell me if you disagree or have concerns about it, that she would be able to say, these are the things I want, and then Mr. Wyman could say yes or no. And if he says yes, then we don't have an issue. And she might also be able to identify items that she believes should be in the house that are not, to the point of her assertion that trust assets, personal property trust assets, have been removed from the property and not accounted for. And if there were items like that identified, then the court might be in a different position to make an accounting. But what I have not heard so far is a reason to restrain or delay the date of the lake property sale. Now, that doesn't mean that Ms. Wyman couldn't provide me with some specific information about why it needed to be delayed, but I've heard good information from the trustee about why it's important, if we have this sale and have the closing scheduled, to go forward with it. And um, I've not heard good evidence or justification for why Ms. Wyman could not get to the property between now and September 14th, or somehow access the property to review it herself. And if she can review it herself, then I'm not sure I understand why an accounting is necessary.
Your Honor, and if you may, I may want to speak with my client and figure out, the logistics as well for that answer specifically, because I haven't
Sure.
quite spoken to her about that. But it's more in fear of whether or not the trustee says, no, you can't take certain property, and we're the night before the closing. We don't have an opportunity to come back to the court before the closing, because history has shown that he has, followed through with the closing of other property without regarding, my client's interests. So that's the fear that, and I'm specifically talking about the farm property that was recently closed as of, I believe, July 30th. So,
Okay.
but I can speak with my client and figure out logistics as to whether or not she can or cannot go up there in the time frame that, we're afforded.
Okay.
If we can do
I mean,
that.
I'm just pointing out, I mean, and I don't, please don't take this the wrong way, but right, all of you are busy professionals. I am a busy professional, and yet we all stopped what we were doing and had a hearing today. So that means that what we did was prioritize this because we thought it was important. You stopped what you were doing to draft the extensive pleadings and motions that you had to do. Ms. Wade dropped what she was doing to draft a response. You all dropped what we were doing to be here today. And what I'm telling you is that today is the 25th of August. That gives us 3 more business days after today, a half business day today, 5 more business days the week after that, and then 4 more business days the week after that, with a closing scheduled on Monday, the 14th. And then there are weekends in between. And so what I'm saying is that if this is an issue that is important to Miss Wyman such that she feels like she needs injunctive relief, etc., then she will need to make some decisions about prioritizing her ability to go to the property. Because as we sit here now, I'm telling you, the 7th of September is Labor Day. But I'm telling you, I can host another injunctive hearing the week of September the 8th so that we can have a delineated conversation. If Miss Wyman identifies property that she believes is missing, we can deal with that.
Yeah.
Or identifies property that she wants to take that she's now been told she cannot take before the closing on the 14th. Those are things that we can accomplish even in this small window, but we have to all be prioritizing it to try and accomplish it in that window.
Right. There are two items that just have come to mind while you were speaking.
Yes, sir.
That may cause some sort of a delay. Is if if Ms. Wyman has to retain a moving company for any reason, we're under their schedule. So that may be, a cause for any delay. The other one that's more prevalent from what I understand is that concerning the firearms. Now, it's been our understanding through Michigan Counsel that, you can't just give someone firearms and then them go ahead and transport firearms across state lines without registering things.
I don't know where they're from. You can dang sure do that in Georgia.
Not in
Obviously,
Georgia, but in
different
Michigan.
states have
Apparently
different
in
rules,
Michigan,
but
yeah, in Michigan,
yeah.
apparently that's a thing. And so we were trying to get some guidance on that up in Michigan.
Well, I feel like if you're going to purchase firearms, then it's your job to be an intelligent firearms purchaser and handler. And so,
Yeah.
make sure that you are prepared to, make the firearms safe
Right.
and travelable either for shipping or
So
for
right.
vehicle
So-
transport.
So one of the things that was brought up to
I mean,
my
for
attention,
$1,000, we can't be talking about that many guns. Did I hear 2 shotguns or 2 rifles?
I think there are multiple weapons.
I think
I'm not
Suzanne's going to get a very, very good deal.
Yeah.
Actually, Your Honor, I think is what's happening there.
Yeah, but it's been brought to my attention through Michigan Counsel that it's likely the trustee's responsibility to register it with the sheriff's office, or there's some paperwork that's involved there, and that hasn't come to fruition as of yet, which is why we're kind of at a standstill regarding the weapons. And so I don't know how long that's going to take. I don't know where the weapons are going to be stored until that time is, because everyone is not in Michigan.
Yeah,
So
I'm no
that's one
expert
of those
on
issues, right?
I'm no expert on Michigan gun law, but that seems like that would the extent of the regulatory burden for, I mean, perhaps for a handgun if some are involved, but for anything that would remotely be referred to or described as a hunting weapon, a shotgun or a rifle, I can't imagine that any of those rules apply.
Yeah.
But again, those still seem like navigable hurdles for a closing that is scheduled for the 14th of September. And again, if in fact Ms. Wyman may need a moving company, then that is a meaningful conversation that she needs to be having with the estate, because it sounds as if she's been, again, I'm only accepting at face value, but it sounds as if there was a miscommunication at some point about what she could or couldn't take when she went to the property some time ago. But if Ms. Wyman is going to say, I want all of the contents because you said I could have them, then that's a different caliber of discussion that we'll need to have, given that the argument I'm going to hear from Ms. Wade is that Ms. Wyman agreed to a sale contract for this property that included all the furnishings, and now she's saying that she wants all the furnishings. And so, but we can deal with that. But right now, we are looking at a 9-day window in which to address those issues. And if we, I mean, that's sort of where I am keyed in on. Again, I don't want to, I don't want to overstate what my position is, right? But because I want to be clear that there is a lot here that the court has not been educated about. The court does not have in front of me in terms of the broader strokes of what the trust document is, what the trust document allows the trustee to do, et cetera. But in terms of the issue that is in front of me today, the burden that a party seeking injunctive relief is required to establish, I don't believe that Ms. Wyman has established it to require the court, or not require, but to persuade the court that it's necessary to enter an order delaying the sale of the property, that it is necessary to enter an order delineating what personal property Ms. Wyman may obtain. Now, if we want to talk about some sort of procedure, then perhaps y'all could talk about it and I could tell you what would be reasonable or not. But again, as I understand it currently, that may come back to haunt us all, but the general statement is take what you want. And then we'll have to figure out what that does to the purchase and sale agreement, and that will be the problem of the trust. And then, as I mentioned, if we are talking about an accounting of the trust property limited for purposes of today's hearing, and the current motion, an accounting of the lake house property, again, if Mr. Wyman, as the trustee, is offering access to the property so that Ms. Wyman can view and take what she wants with some discussion, and also identify property that she believes has been removed, then I'm not sure I believe that an accounting is necessary at this juncture. Ms. Wade, looks like you started to say something.
Thank you, Your Honor. Yes, I just wanted to be clear that I was not misstating my client's position or, misconveying it, but the take whatever you want was before he agreed that the furnishings, right, and before she agreed that the furnishings would be included. So he would have a problem at this point if she wanted to back up a moving truck, because what's in the contract is already been committed to go. Now, when we're talking about knickknacks, small personal items, anything like that, I think would be fine, and I don't think the buyers want that stuff, right? But furnishings, like, furniture, appliances, the boats, the things that are specifically identified in the contract, it is our position that those are going, and that Ms. Wyman has already signed off on that. And I want to point out one more thing, and I know Your Honor's not getting into the terms of the contract, but again, I don't want to leave a misimpression. It seems pretty clear to me from the language in the trust agreement that there's not even a requirement to do a round robin or let her pick what she wants or anything like that. What the trust says is that the personal items will be split between them in shares of substantially equal value. Under Michigan law, which applies to this trust instrument, my client has authority to make distributions in kind or in dollars. So selling items as part of this property and then Ms. Wyman getting her half of that is a distribution of the personal property. And that's how they're doing a lot of this. So I just want to be clear that it's not my position that she would have been entitled to anything she wanted, but it's my position that that's what my client said she could do. But again, he has worked with her in ways that he didn't have to under the trust. I just want to be clear that I'm not saying the trust entitles her to take whatever she wants. That is simply what my client told her that she could do. Oh, you're on mute, Your Honor.
And it would not be a Zoom hearing if somebody didn't have to say that at
That's
one
right.
time. I apologize. And I appreciate the clarification, but I did not understand you to be making that representation. The reason I keyed in on it is because the purpose of an injunction is to maintain the status quo or to restrain some action from which there might result an irreparable injury. And what I have not heard, given that the trustee's position, as stated here, was if she wants to go and take some things, then she can take some things. But we haven't actually had the next step of that conversation. Well, these are the things I want, and he won't let me have them, either because he just won't let me have them, or because they have already been, promised as a part of the purchase and sale agreement. And
We
so
want to be misleading the court in our position. So
I understand. Mr. Sobel, we've sort of gotten into a little bit more of a conversation. If you want to, I want to give you the last word, sort of a last opportunity to wrap up these discussions before we adjourn today.
Okay. Well, I do want to mention that, the contract does explicitly say furniture, furnishings, pretty much everything inside the house. And so, my client will be going in and removing things that are part of that contract. One of the discussions that my client was having was concerning this boat and whether or not this boat should even be included in the deal or whether or not she should take it. And obviously, her share of the boat. That may be a big issue in this situation. Um, in terms of, if my client gets to the point where she is allowed the opportunity to go there and then is refrained from removing the items that we have clearly indicated that we want, there may be not insufficient time to come back to the court. In terms of the time frame, I can speak with my client in terms of the exact items that she's looking for that she knows of right now, but that list could change when she gets up there. The boat, a lot of the furnishings inside the house, my client, would like to consider taking some of that stuff as personal items from the trust. We did offer a round robin approach well before they even entered into this contract. So this should have never been a breach of contract situation concerning the buyer.
I don't exactly know what the timing is, but where does the offer of the round robin through Michigan Counsel, where does it come in relation to Ms. Wyman's approval of a prior sale contract that that included the furnishings?
So previously the property was sold at like 1.6 million. Previously or since then the property has been reduced to
Right, no, I'm aware of that, but I was just asking about the timing.
If I'm not mistaken, I think that was in March or maybe even early as February. But that landed up falling through. And so, the reason.
Right, but respectfully, Mr. Sobel, that wasn't my question. My question was, my understanding is that a prior contract for the purchase and sale of the property included its contents, and that Ms. Wyman, setting aside whether she was entitled to give her approval or required to give her approval, had said, yes, that's fine, go ahead. And that included the contents of the house. Now, I understand you might argue that, yeah, but that was for a different price and whatever. But my question is, when was that relative to her? Was it before or after a discussion about a round robin opportunity to go into the house and claim certain items of personal property from inside the house?
So the $1.6 million offering was at around the same time that there was discussions of everyone going up to the property, but there was that misunderstanding that Suzanne was going up there to collect not only her personal possessions, but as well as the tangible personal property of the assets. And so there was
So I
all
guess,
all
I
at the
mean,
same time during that conversation. And so by the time that the house was going to be listed and sold and being under contract, the argument would have been, at that time, everything would have been removed from the property at that time, but and never came to fruition.
and I guess where I'm still stuck a little bit is, and I don't know that I've gotten a clear understanding is the issue with the personal property uh, sentimental attachment or historical attachment to it? Or is it that Ms. Wyman doesn't believe that the value of the personal property in its entirety is properly reflected, that the trust is not getting fair value for the house and its contents? Because as I understand it, there were two appraisals, one at 700 and one at $1 million, and the property is now being sold for 1.4, right? Which means there's about a $400,000 window in there that comprises perhaps some additional value over and above, what a seller would be willing to pay for it over and above the appraised price, but also the value of the contents. And
Correct.
so I guess that's what I'm struggling with is Miss Wyman's issue that she thinks the personal property contents are worth 500,000 and she's only getting they're only getting 400, so her share is only going to be 200? Or are we talking about there's a painting on the wall in the kitchen that was my mom's and I love it and so I want it? Or there's stuff on the shelves that were books that were my dad's and so I want those. Like, I'm still not clear on what the issue is.
Yeah, so this is absolutely sentimental value. She wants to go get her mom and dad's stuff. She hasn't even had an opportunity to do so. There is some argument or discussion about whether or not the boats themselves increase the value of, whether or not it's financially fit for the trustee to include that in the sale of the property. But when the properties were listed at a higher valuation at 1.6, it was worth throwing in the boats for that valuation. But now we're at almost $200,000 less than the 1.6 million that was in there. Originally, it was disclosed that there was strong interest in valuing the property at 1.85. And so now we're talking about a $550,000 difference between what we agreed upon, including everything, to what we are today. But she absolutely wants to go in and get her mom and dad's stuff, holds high sentimental value, not sure of the fair market value on the open market, nor do I think my client really cares what the value is on the market.
Well, to be clear, where we're going to end today is that I do not believe that Ms. Wyman has demonstrated that the court needs to take action to maintain the status quo, and for purposes of a temporary restraining order, and for purposes of a longer term injunctive relief. I don't believe right now, that doesn't mean that it couldn't happen, but that I don't believe that right now Ms. Wyman has demonstrated the danger of irreparable injury that requires court intervention to avoid. I will say that the reason I asked the question about what is the focus is it's one thing to say it's sentimental value, but then you said her mom and dad's stuff. And if that's been their home for 30 plus years, then literally everything in it is her mom and dad's stuff. And that seems a little bit, that seems like something that will need to be sorted out because there's really no universe in which, as I understand the trust, right, Ms. Wyman's supposed to get half, or more correctly, the value of half, which is what I think the trust document amendment says when it said all of my personal belongings, et cetera. And so taking all of her mom and dad's stuff, literally the entire contents of the entire inside of the house, would actually be more than Ms. Wyman is entitled to. And it would border on unreasonable from a sentimental perspective to say, I'm going to take the entirety of the contents, because what are you going to do with those?
And Your Honor, let me clarify as well. We're not talking about the entire contents. We are talking about selective items that
No,
are.
I thought you were, but when you said stuff, I wanted to let's be clear about the scope of what we're talking about.
Yeah, and I can clarify with Ms. Wyman as to exact things that she's looking for if you want an answer today for that.
Okay. And I don't need an answer today, but here are two things that are going to happen as a result of this. Well, maybe three things. Ms. Wade, can you please draft a proposed order that denies the request for temporary injunction? I don't need a tome or a treatise, just something relatively straightforward to reflect that the court heard argument of counsel, and had the benefit of significant presentations and supporting evidence from Ms. Wyman. The court was also presented with materials from Mr. Wyman, although admittedly have not had a chance to review that in great detail today. And that based on that, the court has declined to enter to grant the injunctive relief that Ms. Wyman was seeking here. That is not a judgment as to the going forward merits of the case, and it is not a judgment as to any later effort or need for the court to consider injunctive relief on any aspect of the trust. But as I understand it right now, as I mentioned, what I'm being asked to do is consider whether or not to restrain the closing of the lake property in Michigan, which is currently scheduled for September the 14th, whether or not to partially do that so that Ms. Wyman can retrieve personal belongings from the property before its closing, and to require an accounting of the trust property. And at this point, I am not going to grant that relief. So that motion is going to be denied. That's number one. Number two is I'm going to order Ms. Wade and Mr. Sobel this week to speak with their clients and then talk with each other about what might be accomplished to resolve these more immediate issues in advance of the September 14th closing. Because obviously we've reached the point of litigation, and so probably nobody's going to be happy with the outcome, which is usually what happens with litigation. But if the parties can really get down to brass tacks of what they're trying to accomplish and can determine if it can be accommodated in a way that both parties can live with, then that would be a valuable use of both Ms. Wyman and Mr. Wyman's time, and both Ms. Wade's and Mr. Sobel's time. And so I am going to require that y'all have some sort of conference this week on that issue. And then what I will tell you is that that was number two. The third thing is, if the parties wish to revisit this issue after Ms. Wyman has had an opportunity to, either through going to the property, through her own memory of items that she wants, that she knows are there, through perhaps a cousin and photographs, there are different ways this might be accomplished. But I can accommodate a hearing the week of September the 8th, which of course, if we did it earlier in the week, would give the parties, and I will say that the 8th would be better, which is a Tuesday. But I could also I can basically do any time that week. But you would have the most ability for us to get really down into the weeds and work through individual issues on that Tuesday the 8th. The benefit, if we were to do it on Tuesday the 8th, is that then gives the parties multiple days to accomplish, 3 business days and 2 weekend days before the actual closing is to occur. Because I understand that once the closing occurs, and this is part of, just to be full disclosure, part of my reasoning here is that once the closing occurs, if we are talking about sentimental value items that Ms. Wyman was not allowed to retrieve, that is something that the court might be willing to consider injunctive relief, because those are items for which, I mean, yeah, technically there's a monetary way to compensate someone for the loss of that, but we all know those things are unique to our childhoods and to our families. And so I would want to try and protect that to the best ability that the court has. But beyond that, if we're talking about the value of personal property, the boat, things like that, then the court is likely to find, and that is part of my motivation here, that Ms. Wyman has an adequate remedy at law in the form of a claim for money damages for breach of fiduciary duty or loss of trust property that should not have been allowed to be lost. And because of that, that is one of the considerations that goes into determining whether or not injunctive relief is proper, is if there is in fact an adequate remedy at law, which other than potentially for identifiable, and I'm not saying they might not be valuable, but identifiable emotional value type items, those might be subject to some sort of injunctive relief if we get to that point. But it feels like there needs to be more work done to identify what we're actually talking about. And so, again, where we're leaving it is I'm denying the request that Ms. Wyman, the motion that Ms. Wyman has filed today. Ms. Wade's going to prepare a proposed order, and if you'll just email that to Mr. Freehoff in Word format. Of course, Mr. Sobel will be copied on it. And Mr. Sobel, if you have any concerns that anything that Ms. Wade says in that proposed order does not accurately reflect what I've said here today, then you're free to share that with Mr. Freehoff so that I can make sure. But I typically do review the orders and edit them. So, you know, I promise I will do my homework when I enter an order. That's number one. Number two is I'm ordering the parties to confer on these issues this week. And then what I'm telling you, I'm not setting it for hearing, but I am telling you that the week of the 8th of September, in the lead up to the planned closing on the 14th, that the court can accommodate a further hearing on any injunctive relief or issues that remain regarding any potential, items in the home of personal property that the Ms. Wyman wishes to take, that the trustee has said, no, they're part of the purchase and sale contract and you can't have that. Yes, Mr. Sobel. And that was the next thing I was going to say is, starting with Mr. Sobel, do you have any questions, concerns, issues you want to raise relative to what I've just said, or any other issues that you need me to address today?
I just want to clarify in terms of item number 3,
Yes,
when
sir.
would be the latest to notify the court of rescheduling a hearing if we have to?
So I honestly, anytime before that week, like anytime that Friday, right? Or that even that weekend, because Monday is a holiday. If you email us, we will still get that notice. And so, as I said, that Tuesday, I can put in a placeholder, and it would be more like, I would just need you to tell me you don't need me.
Got it.
Then, and I could sort of plan for y'all to need me just in case.
All right. Yeah. That would
But
make more.
ideally, the Friday before would be best.
Okay.
In a real pinch, if we are up against a time wall, that weekend, y'all could notify us and we could still try and make something happen that week.
Okay. All right. Thank you, Your Honor. I appreciate the clarity.
Ms. Wade?
And I just want to be clear that you want all of that in the order, including the part about we can come back and the court may be willing to consider injunctive relief if it's something sentimental. And do you want all that?
I want item number 2 about the requirement for conferral. And
Yes.
as to item number 3, I don't know that it needs to be that granular, but I do want you to say that the court has set aside time the week of September 8th to host a conference for further disputes that the parties believe the court might need to consider in the context of the request for injunctive relief.
Perfect. I was trying to write it all down. I just wanted to make sure I wasn't over including. Okay, thank you.
Understood. Anything else or any questions about what my ruling is? Ms.
No,
Wade?
Not at this
Mr.
time.
Sibel?
Nope.
Okay. And then my last piece of advice is I really hope you both are quite able counsel. It's clear that you know the background and information. And so my hope always springs eternal, and hope that the parties can maybe get to not making everybody happy, because by the time you get to litigation, that can't happen, but at least getting to something that everybody can live with and be able to move on. Because I understand, I'm not a probate judge, but I do understand that there's a lot of emotion that overlaps all of these issues. And so I know how difficult it can be for everybody, even when we're all operating in good faith, which I always assume that we all are. So thank you all for your time, and I will see you again if I need to, or I will look forward to any communication with the court that the parties have resolved these issues. Beyond this, the last thing I'll mention is I will wait for an answer to be filed on behalf of the trust. And then what you can expect will happen is I will enter a scheduling order. I will give you notice that I'm going to enter a scheduling order, and y'all can choose whatever dates you want. And then you will be on a sort of, if either of you litigate in federal court, you'll be on sort of a federal court type schedule, which is that it's going to tell you when to disclose any experts, and it's going to tell you all this stuff. And hopefully I won't need to see you again if the case goes beyond that until motions practice pre-trial. But I am here for discovery disputes, and I encourage you to read my standing case management order, which talks in probably incessant detail about how to handle discovery disputes. But beyond that, thank you all very much. I am, again, Ms. Wyman and Mr. Wyman, sorry for the loss of your father. And I wish you the best of luck in hopefully being able to resolve this issue.
Thank you, Your Honor. We appreciate your time.